So today we finally got that long-awaited ruling on whether or not Donald Trump violated the gag order in his New York election interference case. The prosecutors flagged 10 instances, 8 from social media, 2 from his campaign website, that they said ran afoul of the judge's order. Most of the posts attack Michael Cohen, citing a New York Post article calling him a serial perjurer. Others go after adult film star Stormy Daniels and former prosecutor from the DA's office, Mark Pomerantz. Now, this morning, the judge agreed with the prosecution on 9 of those 10 instances. Judge Merchan finding Donald Trump in contempt of court, ordering him to delete the post by 2:15 this afternoon, which he did. Trump has also been ordered to pay $1,000 per violation for a total of $9,000 due on Friday. And if he does it again, the judge warned that, and I quote him here, the court will not tolerate continued willful violations of its lawful orders, and that if necessary and appropriate under the circumstances, it will impose an incarceratory punishment. I'm joined now by LaDoris Cordell, who serves as a judge on the California Superior Court, still with me here at the table, Harry Litman and Lisa Rubin. And Harry, you were saying something that I cut you off before we went to break. But well, do you remember what it was?
No.
Okay.
But this was real. You buried the lead just now, because this is the first time Trump has heard next time you're going in. Because what preceded this was Merchan saying the money just is not effective. And really, he has now, raised the hammer and said, next time I'm coming down.
Lisa, you made the point that the $1,000 fine, for instance, is statutorily prescribed by New York law. Judge Cordell, you were with us here, and you had made a point that a lot of people took a lot of notice of, and I've heard back from folks who talked about your point that you made here on this air, that you can say, look, there is going to be jail time, and I'm not going to tell you how much it is or where it is until after the trial, so that you try to get this disincentive effect. What do you think of the ruling by Judge Merchan today?
The judge's ruling was totally within his discretion. He found 9 violations, but there's a bit of a dilemma he's created, and it's that he has another contempt hearing coming up on Thursday.
Right.
And that's 4 more alleged violations. So if the judge finds that all of those were, in fact, violations of his gag order, I think most people would think, well, then, he's going to send him to jail. Well, he really can't, because what he said today was that going forward, if there are any more violations, these 4 preceded it. So now we'll have maybe 13 or 14 violations, likely with more fines. So had the judge had the 2 the violations, put them all together and had one hearing, I think we'd have a different situation here, where the judge probably would be inclined to say, okay, that's enough. You're going in.
That's a great point, an important one, because subsequent violations don't count for this hearing Thursday. I just want to enter into the record here some of the posts by the defendant in this case, which, again, this is all very unusual. This really doesn't happen. The judge has taken away my constitutional right to free speech. I am the only presidential candidate in history to be, all caps, gagged. This whole trial is rigged by taking away my freedom of speech. The highly conflicted judge is rigging the presidential of 2024 election interference. He also said this is a total witch hunt. Hours of sitting down and listening to nothing except exoneration and lies. The trial is going like a speeding bullet because the judge is working hard to make all of his friends happy. He's rigged, crooked, conflicted, disgrace to our country.
This is today.
This is today. This is today. Now, one of the things he says here, and we've sort of made this joke before, that it's going too fast and too slow. Like he's sitting there so much, but it's going so fast. And two things to bring up here. One is, the thing we discussed in the last block, which is the refusal to stipulate, is elongating the trial time, correct?
Absolutely. It's hard to see how it couldn't. The fact that you have to bring in the guy who's the head of C-SPAN archives from Indiana with his counsel to go through the process by which C-SPAN records and keeps video archives of campaign speeches and make the jury sit through that too. Imagine how many more times we might have to go through similar things for other videos, for example. It can't help but elongate the trial. And this is a guy who's blaming Alvin Bragg for keeping him off the campaign trail when his lawyers and he have made choices that are keeping him there for longer.
Not only that, just to follow up, he doesn't appear to be enjoying himself, and I can't imagine I would either. I don't think this is a strange or character flaw. He does a lot of resting of his eyes. We can't say what's going on. This is long saying the rosary in his head. This is reverie about campaign speeches, or he's falling asleep. Whatever it is, his eyes are closed a lot in that room.
His eyes are closed a lot. And to me, what I will say is he appears to be at rest for considerable periods of time. You know, I spend a lot of time with my nose either in my phone or my computer at the courthouse trying to transcribe or capture moments for you and our other colleagues here. But every time I looked up today, particularly during the first part of the day, Donald Trump's eyes were closed. He could have been meditating. He could have been napping. That's not for me to say other than I think he appeared to be at rest.
I brought binoculars. REM we're talking about. Seriously, he was under.
Judge, let me ask you this question. The pacing of the trial so far, I want to get your sense of how you think it's going. Obviously, there is the fact that defense won't stipulate to these sort of archival, to these records. They have to bring in experts. But what do you think about the pacing so far?
So it's really the job of the judge to make sure the trial is moving along. And I know when I was on the bench and I had many jury trials, I was always looking over at the jurors. They were always looking at me, too, but to see if they were with us, basically.
Right, yes,
and
that's
I knew
key.
if
Yeah.
saw some people, saw them nodding out, then we take a recess. So I believe the pace is good. These jurors are genuinely interested in what's going on in the courtroom. And I think it's true, basically, of all juries. There may be a few exceptions. They really want to do the work, and they are paying attention to what's going on, and they know this is important. You know, and if I could just say one thing about the fines that
Please.
Judge Merchan imposed, I put out a call to New York legislators. They need to amend the statute that punishes criminal contempt in New York. It is ridiculous now to have a maximum fine of $1,000 per violation. It was probably right at the time because I don't think they ever envisioned having somebody really, really wealthy just blatantly ignore the orders of the court. So I hope that happens sooner than later.
On the point of juries, you know, this is a hobby horse of mine, but if you'll indulge me to briefly ride it, you know, it is the case that people's ability to pay attention for long periods of time, all sorts of empirical evidence has pointed to that ability shrinking. And obviously we understand why that is. We have constant stimulus and distraction. And even just thinking about, I mean, this is happening every day across courtrooms across America. So this is just a slice of that. But the idea of remaining attentive and fixed for this period of time, not looking at your phone, not looking at other things, for everyone in that room, it has taken on a level of difficulty or strangeness in the normal course of things that I'm curious how you feel like when you check in on the jury, how you think they're doing in that score.
I actually think they're doing really well. They all have, Chris, as you know, an individual monitor in front of them. And that certainly helps, particularly when an examination is document intensive, because their eyes are fixed on, for example, the individual texts between Davidson and Howard, or the emails between Davidson and Cohen. They certainly looked really attentively at the bank records that other people might be bored by. They're really interested in the details, but the technology in the courtroom is assistive to them in that way, in helping them stay engaged. They're closer to the players than anybody else, and they've got their own personal monitors with the exhibits demonstrated for them. So it definitely is aiding the jurors' ability to pay attention. That having been said, I think this particular jury is especially attentive, more attentive than, for example, the two juries in the E. Jean Carroll trials, who I thought were also fairly attentive.
I would say it's ebbing somewhat. And there are a couple people in particular. It's the best part of being in the courtroom, to really focus. There are a couple jurors who you think, if he's got a shot at a hold on, maybe it's they. But they have come in and out. And the text we were talking about, where he's so apt, you could see their attention come forward. But it's waned, I think, even in the days that I've been there. They're pretty good, but they're not at the edge of their chairs. There's much less note-taking than there was.
Judge LaDoris Cordell, Harry Libman, and Lisa Rubin, great to have you all. Thank you very much.
Thank you for having us. Also,
you can get much more insight into what's been happening in the courtroom during this trial in the latest episode of my podcast, Why Is This Happening?, with Lisa Rubin. We got to talk about the trial. It was great. It is available wherever you get your podcasts, so check it out.